Financial Insider Weekly. I'm your host, Michael Gray, CPA. My guest today is Jim Quillinan, who is an attorney with Hopkins & Carley here in San Jose. He's an attorney and shareholder with the firm, and he's the chairperson of the Family Wealth and Tax Planning Department here in San Jose, California. And now you have an office also in Palo Alto?
Yes, we do. It's been open a little over a year now.
Okay. Been practicing law since he graduated with his law degree from the University of Santa Clara in 1974. Jim is highly respected in the legal community. He's a frequent lecturer and author for the State Bar of California and continuing education of the bar. Serves as a special master and referee in Santa Clara County and San Mateo County Superior Courts in complex trust and probate matters. Jim loves to go to the movies. His movie reviews are very popular. If you would like to subscribe, you go to www.hopkinscarley.com and you can get them by email for free. And I'll tell you, this guy loves to go to a lot of movies. Anyway, Jim also made an appearance on the David Letterman show, so I'm thrilled to have him as a guest here with me today. Today, we're going to be talking about planning issues related to real estate change of ownership in California. And so before we get started, I want to caution our viewers that this is just an introduction to a complex number of issues, to help you become aware of them for further discussion with an attorney or with another tax advisor who's familiar with them. And this isn't an issue that is discussed regularly in the tax consulting field, so you're getting some special stuff today. So with that, Jim, thank you for joining me today.
Oh, it's my pleasure, Mike.
It's great to have you as a guest. All right, let's get into our questions. First, why should California residents who own real estate be concerned about change of ownership rules when they're doing income and estate tax planning?
Well, it gets back to the core analysis. Some of us remember good old Prop 13
yes.
from the late 70s, which has a lot of people having artificially low assessed values for their property. And you're able to keep that low assessed value, despite what the true fair market value of the property is, until there is a change in ownership. And change in ownership is a defined term. Classically, if you sell your house, you sell it to a third party who's not related to you, that's going to be a change in ownership, and there's going to be a reassessment at that time, and the property taxes then will increase. Generally, it's 1% of the assessed value plus bonded indebtedness. So if you've lived in this valley for a long period of time, you may have a piece of property that has a fair market value of $1 million, but you only paid a couple $100,000 for it. And they can increase the value a little bit every year, 2% under the rules. And so you might now have a tax base of $400,000, and that rate would be $4,000 a year property tax. But if you sell it for $1 million, that's a change in ownership. The rates that property tax is going to be $10,000 a year or thereabouts. And as I like to say, this is the gift that keeps on giving, because once it goes up, it's up every year, and then it resets the base, and then you have that 2% automatic adjustment every year moving forward. And so over a period of years, that additional property tax can be fairly significant. And when people are doing estate planning, you may restructure your ownership of your real estate for a variety of reasons, and that can trigger reassessment under these rules. And so understanding how those triggers are and what the exceptions are is very important. So that's why we have to do it when we're dealing with trusts and estates.
Right. So just, again, for people to get an idea of what we're talking about, first of all, we may even get some people that see this that aren't even in California, and maybe they're just curious, I don't know.
Mm-hmm.
But I bought my home that I'm in right now in 1978 for about $100,000. That home now is worth maybe about $700,000. So it's a big change of what's happened now. You know, there have been adjustments, collapse in the real estate prices in general, but it's not quite as dramatic, at least not in Santa Clara County, as it is in some other places. So, and it all depends on when you got it. You know, so if you got it 2 years ago or 3 years ago, maybe it'll actually go down.
And that there has been a lot of that. There's been a lot of reassessment downwards. You can ask the assessor's office to reappraise your property if you think it's dropped in value.
Yes.
And they will do that for you. Mm-hmm. They're very busy doing that at the moment.
Yes.
So if in fact it has dropped, it's, you know, where we are here, there haven't been precipitous drops, but if you've bought real estate in 2006, 2007 out in the Central Valley, you may have paid $400,000 or $500,000 for a home out there then that's now worth $150,000.
Yeah.
That's a huge change.
Yes.
And there are you can just, actually it's very easy to do. You can get these forms are available on the web, or you can call up the assessor's office in the county, and they'll send you the form and they'll go out and reappraise it for you. And if in fact it has dropped considerably in value, they'll adjust your base downward.
Right, but that's sort of a temporary adjustment. So
Correct.
What we're talking about is like the real base that sort
Yes.
of, like you said, it is the gift that keeps giving into the future. All right, well, what exceptions for reassessment apply for families?
Well, there are well, actually it's really three major ones. The first one is that any kind of transfer to a spouse or a registered domestic partner is 100% exempt, anything. So whether it's your home, commercial property, if you transfer it to a spouse or a registered domestic partner, that is not considered a change in ownership that'll trigger revaluation. Then the next category is children, and there's two rules that deal with children. The first one is it's the principal residence can be transferred to a child or children, and that will completely escape reassessment also. And then on top of that, as to something other than a principal residence, you can transfer $1 million of assessed value. This is really important because the assessed value can be much lower than the fair market value. Right. So $1 million of assessed value can be transferred to child or children and escape reassessment. It's not deemed to be a change in ownership. And then last but not least, and this is really, really tricky, you can get an exception for grandchildren that will be treated as if they were children, but they have to be orphans. Even their living parent can't have any interest in all this. It's a very tricky set of rules. It doesn't happen very often, but if you are going to have a situation where it's going to pass to grandchildren, you need to check with your tax advisor and make sure that you would fit in. You may not fit into this last little exception.
Yeah. So it's but there's a void there in most cases. So the children have had
the parent has to have died.
Yeah. So no parent. So now it can go to the grandchild because they're like the next generation.
Yeah.
Okay.
So.
Okay, it's sort of the generation skipping of change of ownership rules.
Yeah, it's sort of the reverse generation skipping, I guess. It's not done on purpose. It's done because someone unfortunately passed away.
Yeah. Okay. So with these family exclusions in mind, how can distributions from an estate or a trust be structured to avoid reassessment?
Well, it gets a little tricky. The first one, obviously, transfer to a spouse. It can be transferred in a trust to a spouse, and then from that spouse to the children, so you can sort of layer your reassessments. But here's the catch-22, or the trick that you got to watch out for. I have 3 children. Only one of them wants my house.
Yeah.
Okay. How do I transfer that house to that one child, and then have that child get the reassessment and have the balance of the family members, treated fairly? And it's important how you structure all that, because if the 3 children actually go on title to the house, and then the one child ends up with it, that's considered being transferred 2/3 from the sibling, two siblings to the other sibling, which will trigger reassessment. So what you have to do is either design in the estate plan the balancing, or you have to have the 3 kids figure out, okay, Johnny wants to have the house, and 2 other people are going to get the money. How do we do that? Now the good news is you could actually do a refinance of the house inside the estate or inside the trust administration to generate the cash so that Johnny gets the house subject to the loan and the other two kids get the money. But that's got to be done just right. And so it's technically called a non-prorated distribution, and it's completely legal, but if you don't do it the right way, it's not going to work. And I've had this happen more than once, where somebody jumps the gun and does the deed transferring the house out to the three kids, and it's pretty hard to put that cow back in the barn when that's happened. So,
Right.
so that's it. You think about it at the front end. You can also think about it in terms of it's like a commercial property. Maybe you'll decide, okay, I want one particular child to have this, and you can give them, say you're going to get it, and you get the, the exemption for that too, and then make it up in some other way to the other kids, because it can be significant. And if it's commercial property, maybe all three of them will go on title together, and that's fine. If they're all three on title, they all get it together. But if one of them transfers it out, it's going to get reassessed as to that pro rata share.
Yeah. So you want things to sort of be settled up, if you will, in the distribution plan itself, rather than after the distribution happens.
Yeah. Well, even if it hasn't been addressed in the actual planning stage, when you get to the administration stage, you can still make it happen, right? You just got to make sure everyone is on board with the techniques, and you're in a position to do it and not fall into one of these traps.
Right.
So
the other thing, of course, is what happens when the county assessor's office gets the paperwork for this stuff. Are they letting this slide, or are they putting it under the microscope?